My name is Mark, and for 11 years, I lived a quiet life on 12 acres of land at the edge of a subdivision called Willow Creek Estates. I want to tell you exactly what happened when the new HOA president decided she could lock me out of my own well, the same well that happened to be the only source of clean water for every single house in that neighborhood. This is a long story, so let me start from the beginning because the details matter. They mattered a lot in the end. My grandfather bought this land back in the 1970s, long before Willow Creek Estates existed. Back then it was just farmland and a scattering of houses along a dirt road. When he drilled the well, he didn't just get lucky. He hit one of the strongest aquifers in the county. The water was clean, cold, and practically limitless. For decades, that well supplied our house and nothing else. Then, in the early 2000s, a developer bought the land next door and built Willow Creek Estates, 42 homes on what used to be pasture land. The problem was, the developer's own test wells came back bad. High mineral content, some contamination from old farming chemicals, water that smelled like rotten eggs. No family wants to move into a brand new house and turn on the tap to that. So the developer came to my grandfather with an offer. He wanted to tap into our aquifer and build a shared water system that would service the entire subdivision, with my grandfather's well as the primary source. In exchange, my grandfather would receive a permanent easement payment, free water for our own property forever, and, this is the important part, full ownership and control of the well itself, along with a legally recorded right of access across a strip of subdivision land to reach the pump house. They wrote it all up properly. Real lawyers, real documents, recorded at the county courthouse. My grandfather signed it, and Willow Creek Estates was built with its water system running straight through our land. When my grandfather passed, the property came to my father, and when he passed, it came to me. Along with the land came the well, the pump house, the recorded easement, and yes, the responsibility of maintaining a water system that kept 42 homes running. I didn't mind. It was steady, it worked, and honestly, most of the neighbors were kind about it. Every so often, someone would drop off a pie or a six-pack as a thank you when I fixed a pressure issue. For years, that was the extent of it. I fixed things, water flowed, everybody was happy. That all changed the year Diane Whitfield moved in. Diane bought the biggest house in the subdivision, a big two-story place with white columns out front, right at the top of the cul-de-sac. Within about 6 months, she'd worked her way onto the HOA board. Within a year, she was HOA president. And within about a year and a half, she'd made it her personal mission to control absolutely everything that happened in Willow Creek Estates, including things that had nothing to do with the HOA at all. I want to be fair here. Not everything Diane did was wrong. She got the entrance sign repainted. She organized a nice little 4th of July block party. She pushed through a rule about parking that most people actually appreciated. But somewhere along the way, she decided that my property, despite not being part of the subdivision, despite not being HOA land, despite having its own recorded deed going back 50 years, was somehow under her authority too. It started small. She sent me a letter on official HOA letterhead, informing me that my unsightly pump house needed to be repainted to match the subdivision's approved color palette. I found this almost funny. The pump house was outside the HOA boundary, sitting on my land, and I wasn't an HOA member. I never had been. I wrote back politely explaining that I wasn't subject to HOA covenants since my property was never part of the subdivision plat. She didn't like that answer. A few weeks later, a survey crew showed up on the access road, the same one covered by the easement, putting little orange flags along the edge. When I asked what was going on, one of the surveyors told me Diane had hired them to clarify the property line, because she believed part of the access road was actually subdivision common area, not part of my easement. I checked my paperwork that night just to be sure I wasn't misremembering anything. I wasn't. The easement was 15 feet wide, ran along the eastern boundary of lots 11 and 12, and gave me, my heirs, and my assigns unimpeded vehicular and pedestrian access, at all times, for purposes of maintaining, repairing, and operating the water supply system. It was about as clear as legal language gets. I called Diane directly, hoping we could clear it up over the phone like reasonable adults. That conversation did not go the way I hoped. "Mark, I think you're misunderstanding the situation," she said, in that tone people use when they've already decided they're right. "That road was always intended to be part of the common green space. The HOA is exploring options to restore it to its natural landscaping." "Diane, there's a recorded easement. It's not up for interpretation. It's the only way I can get a truck to the pump house." "Well, maybe it's time to modernize things a little. I'm sure there are other ways to access a well." I remember sitting there in genuine disbelief. There was no other way. The pump house sat on the far side of a ravine that the easement road crossed with a small culvert bridge. Without that road, the only alternative was hauling equipment through someone's backyard on foot, which obviously wasn't realistic for anything involving heavy parts or machinery. I tried to explain this to her as calmly as I could. She cut me off. I really think you're being dramatic. Let's just say the HOA board will be discussing the matter at our next meeting. I decided to attend that meeting myself. I'm not usually one for confrontation, but I figured showing up with my paperwork in hand would settle things quickly. I brought copies of the recorded easement, the original agreement between my grandfather and the developer, and a letter from the county clerk's office confirming the document was still valid and unmodified. The meeting was held in the clubhouse, maybe 30 residents there. Diane ran the meeting like she'd been doing it her whole life, which I suppose by then she basically had. When my item came up on the agenda, she introduced it like this. Next, we have some concerns about unauthorized commercial activity happening on subdivision-adjacent land, specifically regarding vehicle traffic on what we believe should be designated green space. I raised my hand and she reluctantly gave me the floor. I just want to clarify a few things, I said. First, the road in question isn't subdivision property. It's a recorded easement across 2 lots, going back to when this neighborhood was built. Second, the unauthorized commercial activity is me driving a truck to maintain the well that supplies water to every house in this room. There was a murmur through the crowd. A few people glanced at each other. I got the sense that most of them had no idea their water even came from a private well on someone else's land. They just assumed it came from the city, the way water usually does. That well, I continued, isn't part of any municipal system. It's mine. My family's owned it for over 50 years. The developer built this whole subdivision's water system around it because the original test wells came back contaminated. If I can't access the pump house to do maintenance, eventually there won't be any water coming out of your taps at all. Diane's expression shifted, just slightly, like she hadn't expected me to actually explain the mechanics of it to the whole room. I think that's an exaggeration, she said. The county wouldn't allow a subdivision to depend entirely on one private well without a backup system. There isn't a backup system, I said. There was never supposed to need to be one. The agreement guarantees my access specifically so there wouldn't need to be one. A man near the back, I later learned his name was Roger, one of the original homeowners from when the subdivision was first built, spoke up. He's right. I remember when we all got the notice about the water system, back when we bought our house. It's in the disclosure paperwork. Anybody go back and check theirs? A few people nodded slowly, like pieces were falling into place. Diane, to her credit, tried to keep her composure. Well, regardless, this is something the board can review and get back to everyone on. Let's move to the next item. I left that meeting thinking it was resolved. I was wrong. About 2 weeks later, I drove down to the pump house to replace a worn seal on one of the pressure valves. Routine maintenance, nothing dramatic. When I got to the access road, there was a brand new steel gate across it, padlocked, with a sign that read, Private Common Area, No Trespassing, Willow Creek Estates, HOA. I sat in my truck for a solid minute just staring at it. I called Diane immediately. She answered on the second ring, sounding almost cheerful. Oh, hi, Mark. There's a locked gate across my easement. Yes, the board voted to install some protective landscaping barriers around the common areas. I did mention we'd be exploring changes. Diane, that's not landscaping, that's a padlocked gate blocking the only access to my well. I need to get through today. I'm in the middle of a repair. I'm sure it can wait until the board meets again. We can discuss adding you to an approved access list. An approved access list. For access to my own property, guaranteed by a document that predated her entire subdivision by decades. I want to be honest with you, in that moment I was angry. Genuinely angry in a way I rarely let myself get. But I also knew that losing my temper wasn't going to fix anything. I hung up, drove home, and instead of arguing further, I did something else. I called a lawyer. Not just any lawyer, I called the same firm that had represented my grandfather in the original agreement decades earlier. It had changed hands a few times, but they still had the files. The attorney I spoke with, a sharp woman named Patricia, pulled up the recorded easement within minutes. This is about as airtight as it gets, she told me. They physically installed a barrier obstructing a recorded, unimpeded access easement. That's not a gray area, that's a straightforward violation. And depending on how this plays out, it could even rise to interference with essential utility service, which carries its own set of penalties. So what do I do? First, we send a formal cease and desist, demanding the gate be removed within 48 hours. Second, and I want you to think carefully about this, you are under no legal obligation to maintain water service to a system you cannot physically access. If they don't remove that gate, you may be forced to shut down operations simply because you can't reach the equipment to keep it running. I sat with that for a long moment. Not because I wanted to punish anyone. I genuinely didn't. I just wanted to fix a valve. But I also understood, maybe for the first time really understood, the position I was actually in. 42 homes depended on water that flowed through equipment I alone had legal access to maintain. And now, apparently, I didn't even have that. Patricia sent the letter that afternoon. I have it saved, and it's about as polite as legal letters get, but it laid out the facts plainly. The easement was valid, the obstruction was unlawful, and continued blockage would leave me no choice but to suspend water service due to inability to perform required maintenance, effective in 5 days, with formal written notice to all affected residents as required under the original agreement. I didn't hear anything back from Diane. Not a call, not an email, nothing. 5 days later, right on schedule, I sent the formal notice to every household in Willow Creek Estates, as the original agreement required. It explained plainly and without any exaggeration that due to an obstruction placed on the legally recorded access easement, I was currently unable to perform necessary maintenance on the shared well system, and that water service could be interrupted at any time as a result. I want to pause here and say, this wasn't some dramatic act of revenge on my part. I genuinely didn't want to cut off water to 42 families, many of whom had never done anything to me. But I also wasn't going to keep risking equipment failure with no way to reach it, and I certainly wasn't going to sign myself onto some approved access list for a piece of property that was legally mine to access whenever I needed to. The reaction was almost immediate. My phone started ringing with numbers I didn't recognize. Neighbors, mostly polite, some confused, a few genuinely worried. I explained the situation to each of them the same way. I wasn't the one who put up the gate. I wasn't the one refusing to take it down. All I wanted was what the paperwork already guaranteed me. 2 days after the notices went out, the pressure regulator at the pump house, the same one I'd been trying to service when I found the gate, finally gave out. It wasn't catastrophic, but it caused a noticeable pressure drop throughout the subdivision. Showers sputtering, low flow from taps, that sort of thing. Nothing dangerous, but definitely noticeable, and definitely inconvenient. That's when things really escalated. The HOA held an emergency meeting. I wasn't there for the beginning of it, but Roger, the same neighbor from before, called me afterward and gave me the play-by-play. Apparently, once people realized their water pressure issues were directly tied to Diane's gate, the mood in the room turned fast. Several homeowners demanded to know why she'd unilaterally installed a barrier on private property without consulting a lawyer, without a resident vote, and without even notifying the one person whose cooperation the entire water system depended on. Diane apparently tried to argue that the gate was simply a security measure and that I was weaponizing a minor maintenance issue to make a political point. Roger told me a woman near the front, someone named Carol who'd lived there since the beginning, stood up and said something like, "Diane, he's not the one who locked the gate. You are. If our water gets shut off because of this, that's on you, not him." The board, according to Roger, voted that same night to have the gate removed immediately, overriding Diane's objection. The gate came down the next morning. No call from Diane, no apology, just a crew showing up and hauling it away. I drove down that afternoon, finished the pressure regulator repair within about 2 hours, and water pressure was back to normal throughout the subdivision by that evening. I sent a follow-up notice to all the residents confirming service was fully restored, and I made a point of thanking everyone for their patience, because most of them really had been patient and reasonable through the whole thing. I thought that might be the end of it. Again, I was wrong. About a week later, I got served with legal paperwork. Diane, apparently acting independently of the HOA board this time, had filed a small claims complaint against me, alleging that I had maliciously and negligently interrupted water service to her household, causing what she claimed was over $4,000 in damages, something about ruined houseplants, a malfunctioning water softener, and, I kid you not, a claim for emotional distress. I'll admit, when I first read it, I laughed. Not because lawsuits are funny, but because the audacity of it was almost impressive. The woman who personally installed the obstruction that caused the entire problem was now suing me for the consequences of her own decision. I called Patricia again. She read through it and actually chuckled a little herself. "This is going to be an easy one," she said. "We have the recorded easement, the cease and desist letter with the date it was sent, the notice you sent to residents explaining the obstruction was the cause, and now, apparently, meeting minutes from the HOA's own emergency session, where multiple witnesses state on record that the board itself acknowledged the gate was the problem and voted to remove it. She's essentially suing you using evidence that proves the opposite of her claim." We showed up to the small claims hearing a few weeks later. Diane brought a folder of photographs, wilted plants, a water softener control panel. But when the judge asked the basic question of why the water had been interrupted in the first place, Patricia calmly laid out the timeline. Recorded easement from decades prior. Gate installed by the HOA. Cease and desist letter, ignored. Formal notice sent to residents as contractually required. HOA's own emergency meeting minutes acknowledging the gate as the cause and voting for its removal. The judge didn't take long to reach a decision. The case was dismissed, and the judge actually said on the record that filing the claim against the one party whose easement rights had been violated bordered on being frivolous, and cautioned Diane against pursuing anything similar in the future. Diane didn't say a word to me on the way out of the courthouse. She just walked to her car and left. I wish I could tell you that was the last of it, but there's one more piece to this story, and honestly, it's the part that mattered most to me. At the next regular HOA meeting, a resolution was introduced, not by me, I want to be clear, I wasn't even there, to formally remove Diane from her position as HOA president, citing the unauthorized obstruction of a legally recorded easement, the resulting service disruption to the entire subdivision, and the frivolous small claims suit filed using the HOA's own internal records against her. The vote apparently wasn't even close. A new HOA board reached out to me not long after, this time with an actual olive branch. They asked if I'd be willing to sit down and formalize something that, frankly, probably should have existed from the very beginning. A clear, written maintenance protocol, agreed to by both sides, confirming access hours, notification procedures for planned repairs, and a mutual understanding of what the original easement actually guaranteed. I said yes without hesitation. I never wanted a fight. I just wanted to be able to do my job and keep people's water running. We signed that agreement about a month later. It didn't change anything about my legal rights. Those were never actually in question, but it gave everyone a clearer, friendlier framework to work from, and honestly, it's made things easier ever since. I get a heads up before any subdivision events near the access road. They get advance notice before any planned maintenance, and nobody's had to threaten a lawsuit over a garden hose valve since. As for Diane, she still lives in the same house at the top of the cul-de-sac. I see her occasionally when I drive past. She doesn't wave, and honestly, I don't expect her to. But she also hasn't tried to put up another gate, hasn't sent another letter about the color of my pump house, and hasn't tried to claim my land was somehow part of her jurisdiction again. Looking back, I don't think Diane ever set out to genuinely hurt anyone. I think she just got so used to being the one who made the rules that she forgot some things simply aren't hers to control, like 50-year-old legal paperwork, or a well that quite literally keeps an entire neighborhood's taps running. What I learned from all of it is pretty simple, honestly. Documentation matters. Staying calm matters, even when someone is doing something that feels completely unreasonable. And sometimes, the quietest, most boring piece of paperwork sitting in a filing cabinet for 50 years turns out to be exactly what saves you when someone decides they're entitled to something that was never theirs to take. To this day, the well still runs strong, the water's still clean, and every single house in Willow Creek Estates still gets its water from the same aquifer my grandfather found back in the 1970s. And every time I drive down that access road, completely unobstructed, exactly the way it's supposed to be, I think about how close one person's overreach came to shutting off water for 42 families, all because she couldn't stand the idea that something in her neighborhood wasn't actually under her control. If there's a lesson in this story, I think it's this. Just because someone acts like they're in charge doesn't mean they actually are. Know your rights, keep your paperwork, and don't let anyone convince you that staying calm and doing things by the book makes you the unreasonable one. In the end, the truth and the paper trail usually wins.